Only 7 Cabinet Secretary nominees could be vetted by the National Assembly if Speaker Justin Muturi's directive carries the day. These are the fresh nominees who were named by President Uhuru Kenyatta in his new lineup that sealed the fate of 6 Cabinet Secretaries who are implicated in corruption allegations.
Serving Cabinet Secretaries and Principal Secretaries who have been moved to other ministries or state departments will not require further approval of the House.
Muturi's directive came barely 24 hours after the House resoundingly rejected a proposal by Attorney General Professor Githu Muigai in the Statute Law Miscellaneous Amendment Bill of 2015 that sought to give the President more power to reshuffle his cabinet without referring his nominees to Parliament for scrutiny on their competence and integrity. The lawmakers had cited the Public Appointments Act of 2011 that defines reappointments as fresh appointments and hence requiring even the Cabinet Secretaries and Principal Secretaries who had been transferred from one docket to another to face the vetting panel afresh. These would have required some members of the cabinet who have previously had a run-in with the lawmakers to appear before them yet again for either approval or rejection. Among them is Principal Secretary Dr. Monica Juma, who was moved from the Interior Affairs docket to the Foreign Affairs Ministry. Dr. Juma's nomination to the influential secretary to the cabinet slot was rejected by the National Assembly.
Articles 152, Clause 5, Paragraph A, and 155, Clause 4, allows the President to reassign a Cabinet Secretary or a Principal Secretary, respectively. The interpretation of these provisions is that a person vetted and approved for appointment to the position of Cabinet Secretary or Principal Secretary may be reassigned within the same position by the President.
If Professor Muigai's proposed amendment to the Appointments Act was adopted by the House, Cabinet Secretary and Principal Secretary nominees, once vetted and cleared by the House, would not be subjected to a fresh scrutiny, even if they were moved to other dockets. This, according to the Attorney General, was to save them from rejection by Parliament on the basis of bias or perceptions should they be reassigned by the President.
Vetting of Principal Secretary and Cabinet Secretary nominees is an elaborate process, and though the fresh nominees have no option but to face the vetting panel, it is clear that some of the current serving CSs and PSs may not have it easy when they face the panel afresh, and hence the reason why the executive is keen on insulating them from a second run at the vetting panel.
With Parliament seeking to flex its muscles on the cabinet appointments, it is apparent that the President was keen on shielding his nominees from rejection by the House, a situation that could force him to seek replacements. Sources further disclose that the President sought to tackle instances of rent-seeking and situations where such vetting processes had been turned into extortion avenues by some members of Parliament. Francis Gashuri, Citizen Business Center.